This is Based in Fact, a true crime podcast. Join host Lisa O'Brien as she examines America's most infamous true crime cases through the lens of the court, not the court of public opinion. No spin, no theories, no rumors, just facts. Here's Lisa O'Brien.
In episode 4, I'm joined by guest co-host Kyle to talk about the case against Rodney Reed. In July 2021, an evidentiary hearing on Reed's 10th state post-conviction writ was held in Bastrop County, Texas. Just prior to that hearing, the state submitted two disclosures of information to Reed's counsel, and Kyle and I are going to talk about those disclosures and those witness statements. After the close of the hearing, Reed and the state each submitted proposed findings of fact and conclusions of law to the court in advance of closing arguments, which were held on October 18th, 2021. Kyle and I are going to talk about the proposed findings, the closing arguments, and the findings of fact and conclusions of law entered by Judge Langley on October 31st, 2021. We will also talk about what's next in the case, including the review by the Court of Criminal Appeals and Reed's 11th state post-conviction writ, alleging that exculpatory evidence was withheld based on those 2021 disclosures. On a personal note, Kyle and I extend our condolences to guest Jennifer Harmon and her family. Jennifer's father, Richard R.D. Davis, passed away after a brief illness on February 16, 2022. Mr. Davis was a former lay speaker at Tulsa Indian United Methodist Church. He was a triathlete who carried the 1984 Olympic torch through a part of Oklahoma during the torch's journey across the United States to Los Angeles. He was raised in the Greenwood area, was a Tulsa historian and supporter of the Greenwood Chamber of Commerce. When Mr. Davis discovered the first written term paper about the Tulsa race riot written by a Tulsa student in 1969, he donated it to the Greenwood Cultural Society because it was the right thing to do. Mr. Davis was a motorcycle rider who enjoyed ride-bys by the Tulsa area number 1 hog chapter, and he was a sweet man who was loved and respected by many people all over town. He's survived by his wife of 58 years, his children, and extended family and friends. And again, our condolences go out to Jennifer Harmon. And good afternoon, Kyle, if I can get you unmuted.
Yeah.
Oh, there. Sorry.
No,
there's a lag on the mute button.
Yeah, absolutely. The challenges of Zoom. So yeah, I'm so sorry to hear about Jennifer's dad, but thanks for sharing. That was it was really nice.
That was very sad news. And I just thought, that I wanted to say something about Mr. Davis, who sounds like an extraordinary man that I wish I could have had a chance to meet.
Yeah, absolutely. Sounds like an extraordinary gentleman.
And we're thinking of Jennifer today. All right. So, murder of the Texas versus Rodney Reed. The title of today's episode I came up with was Findings and Conclusions. What's next? So let's talk a little bit, first of all, about the background of the case, because I think it's going to help put what we talk about later into perspective. So the murder of Stacey Stites. It occurred on April 23rd, 1996. Based on the evidence developed at trial, Stacey was on her way to work at the HEB in Bastrop from her home in Giddings. She was somehow waylaid on her journey. Rodney Reed either forced his way into her vehicle or talked his way into the vehicle. We're not sure. And her body was discovered out in Bastrop County in an unincorporated area. The truck was found at the Bastrop High School, which coincidentally is less than a mile from where Reed was living at the time, and 35 miles from Giddings, where Stacey lived. So it's in a location convenient to Reed, but not to Stacey. Investigators during the first 11 months or short 10 months after Stacey was killed, they questioned a lot of people. They took a lot of DNA samples from a lot of men in Stacey's life in various capacities, but nobody ever said anything about an affair with Rodney Reed. None of her coworkers at HEB, none of her friends, none of her family, none of that was ever mentioned. Not even mentioning Rodney Reed as, hey, she was friends with him. Maybe you should go talk to him. He was arrested and he became a person of interest in the case when he attempted to abduct Linda S. on a cold November night at about 3:00 in the morning, when Linda was in Bastrop and stopped at Long Star Market. And he talked his way into her car, attempted to abduct and rape her. She was able to fight him off and get away, identified him to police. After that incident, one of the investigators thought, do we have DNA from Rodney Reed? DPS did, based on an allegation made by a former girlfriend, Caroline. And so they compared Rodney Reed's DNA with the DNA from Stacey's murder. And lo and behold, the DNA belonged to the same person. And that person was Rodney Reed. Initially, Rodney Reed denied knowing Stacey Stites. He told David Board in a sworn statement, don't know her, only know what I heard on the news, that she was murdered. Only after finding out about the DNA evidence did Rodney Reed say, oh, wait, I forgot. We were having a secret affair. Anything you'd like to add to that, Kyle? Oh, his audio must be. You there?
I'm back. I got disconnected for a moment. I'm having a little bit of audio trouble.
No wonder.
Hopefully we'll fight through.
Okay. So anything where I kind of went through a thumbnail, murder, nobody mentioned Rodney Reed, attempted abduction of Linda, DNA match, arrest, lied and said he didn't know her. Then he said, I think he was telling the truth when he said he didn't know her, because he didn't know her. But then he decided to lie and say we were having a secret relationship.
Well, and I think that's an important thing to think about that I don't think people consider. If you look back to those events through the lens of his claims today, where he says, I was having an affair, I was having this very public affair, all these people knew that I was having an affair, you would think that he would be proactive. And again, reminding folks that he had already been through a similar accusation previously in Wichita Falls, which he was acquitted. It would seem like, he would have wanted to go to the police and say, hey, you guys are going to find my DNA in her truck, on her clothes, because we're together. People are going to tell you that we're together. I did not kill her. Here is my alibi. I did not do this. You would think that looking through the lens of today, that is what somebody who was actually having an affair that all of these people knew about, that is how, if that were true, how he would have behaved back in 1996, as opposed to hiding and denying.
Correct. I agree. And it's weird, there are so many inconsistencies. On one hand, he says, well, we had to keep it secret because she's white and I'm not. And this is a racist town. But Rodney Reed dated only white women.
Right.
He did not. None of those women ended up murdered. He wasn't accused of raping them or murdering them, except in the case of when he did. For example, Connie and Lucy and Caroline. And I think if he'd gone to trial on Vivian, he would have claimed a secret relationship with Vivian.
Right. And that's a little bit, I think, of a red herring, Lisa. I think it's easy for people to sort of attack this straw man that in 1996 Texas looked like 1955, Selma, Alabama. And having grown up in Texas, not in that area, but in East Texas, which was probably at least 50% African American, there was barely a stigma of interracial dating in the mid 1990s. I can speak from my own experience. That doesn't mean there's not people that, may have given you a sideways glance, but there was no great underground secrecy of interracial dating. I mean, it was very common, then and even earlier than that. So this idea that, all interracial dating must be kept secret from the community is a complete red herring.
Correct. I agree. I don't, even though they always manage to find somebody to say Bastrop was horribly racist, and still is. I just don't believe that. And, but of course, I guess, racism is in the eye of the beholder. If you don't like the way things turned out, racism is always a good way to diminish the credibility of that proceeding or that interview or that statement by saying, well, that person is racist. You can't believe anything they say.
Yeah, absolutely.
So the next thing, the DNA evidence linking Rodney Reed to Stacey's murder is irrefutable. You can argue and dispute the timing, but Rodney Reed's DNA was found inside Stacey's body, in saliva on her breast, and that was confirmed by his own expert pre-trial. It was also found in 2014 on stains that were swabbed from the pants and the back brace that either could not be tested in 1996 or were not tested because they were believed to be saliva from Stacey.
Right. Well, and that's a good time to remind people, too, if they were having this ongoing consensual affair, his DNA should be all over the truck, fingerprints, window, door handles. The absence of that, to me, just proves that it was not, he was in that truck one time.
Correct.
And that was on the night of the assault and the murder. Otherwise, his fingerprints would have been all over the truck. And the fact that they're not speaks volumes that they were not having this long-term consensual affair.
Correct. I totally agree. The fact that his fingerprints, if he was having a secret affair and she was picking him up in the truck before she went to work and they were going and having sex and then she was dropping him off and going to work, he should have had fingerprints and all kinds of stuff in the truck to prove his frequent being in the truck frequently. Nothing. And I think it's very easy when you're in the truck one time to be careful what you touch, to wipe down anything that you did touch, or to use something over your hands to touch things.
Right.
I remember a bait car episode. I used to watch that every afternoon. And these kids would get in and they'd take the bottom of their T-shirts and they'd use the bottom of their T-shirts on the steering wheels under their hands so that they wouldn't leave fingerprints on the steering wheels. Because they had no clue they were on camera. Because it was a bait car. So it's, that would be very easy for him. And I think we may have lost Kyle again. So I will just go on. We're going to move on to the 2021 disclosures made by the state, which will next week, in coming weeks, will become more of an issue that we'll talk a little bit more in depth about. So Kyle, you back?
I'm back. I apologize.
Okay. That's okay. I can kind of tell when you don't chime in. I'm like, oh, he's having a problem. So I figured we'd move into the 2021 disclosures.
No, perfect.
Now, this is kind of interesting. Apparently, during preparation for the 2021 hearing in July, I believe it was Matt Ottaway, but I could be mistaken because I don't have the letter in front of me, came across a summary or some notes prepared by somebody on the prosecution team in advance of the trial. And there's probably going to be something like that for every single witness in the state's file. And it's a common practice with attorneys. A junior attorney, a paralegal, goes through the various files on various witnesses and kind of types out a summary of everything that they've said, when they've given statements, who they've talked to. Details vary. That's in 1 or 2 pages that the trying attorney can use to prepare cross-examination of a defense witness, to prepare direct examination for a state's witness, to kind of know what the witnesses are going to say when they're on the stand. It's what is called work product, because often with the information provided by the witness, there are also impressions. For example, it could say presents as a good witness, will be credited by the jury, or does not present well as a witness, evasive, belligerent, uncooperative. Those are impressions of counsel, and so that makes it work product, and it's not discoverable by the other side. And I think I mentioned, I would love for the DA to go ahead and just issue a subpoena to Andrew McCrae and say, I want every piece of paper you have on every witness before this hearing, including all of your notes. Because apparently we're entitled to those in this process. And watch how quickly Andrew McCrae bald head blows up.
Right. This would be akin to, a paralegal on, getting a note from a defense attorney saying, our client totally did this. I have no idea how we're going to present a case, so I need your help to be really creative and thorough because our guy's totally guilty. Mm-hmm. And, that's just, it's like an internal memo, right? That's and not the paralegal should,
the paralegal coming up with a pretty creative strategy,
right,
and passing it on to the attorney.
Exactly.
And if the state said, we're entitled to that, the attorney would be, no, you're not. That's a work product. It's called work product.
I guarantee you there's a note somewhere in those initial files that says basically Rodney got off in Wichita Falls running the "we had a secret consensual affair" defense. Let's run that play again and see if it can work.
Mm-hmm. Mm-hmm. Yeah, exactly. So anyway, in spite of the fact that he believed these to have been work product, he did write a letter and provide the statements to Reed's counsel because they did deal with the potential of a relationship between Reed and Stacey Stites. However, they did not provide, none of these witnesses provided a firsthand observation or firsthand knowledge of such a relationship.
Right.
Basically, go ahead.
Well, we talk about this a lot. The themes of a lot of these cases are, it's one thing for me just to spout off talking to a friend, like, oh yeah, I think I saw maybe him and HEB talking to Stacey. It's one thing to say that casually. There's no risk. It's another thing to say, I'm willing to testify. I'm willing to go under oath, face perjury charges to testify what I strongly believe is true. And that is always, in all of these cases, such a critical bridge to whether somebody is telling the truth. It's one thing to claim, whether it's, one-on-one or whether it's on television, to make a claim where there's no risk if you're lying.
Mm-hmm.
But if somebody's not willing to put their money where their mouth is and say, yes, I believe in truth. I do not want, I want the truth to be found. I care about the who actually killed Stacey. I'm willing to get on the stand and testify to this based on my knowledge. And
Correct.
To me, if somebody's not willing to do that, I don't weight it very much.
And, my argument and my statement has always been, if that really were true, why didn't these people say that to police investigators when Stacey was murdered in April of 1996?
Absolutely. If I'm Stacey's friend and I work with her at HEB, I think most people know, right? The most likely person to, people close to them most crimes are committed by people close to the victim.
Correct.
And so most people, I think, that have any sort of, harder ethics would absolutely say, hey, if you looked at this person, I believe this person and Stacey are really close. And the fact that they didn't, to me, speaks volumes. Their silence is deafening.
Yeah. And extrapolating a little bit, some of these coworkers at HEB claim Jimmy Finley was abusive. They claim to have witnessed signs of physical abuse. And so why would they not go to police and say,
Exactly.
Look, she's engaged to this cop and he's abusing her.
Exactly.
And she's having an affair with this guy who comes in the store, and his name is Rodney Reed.
Exactly.
And I think you need to talk to him, because at the time, he probably would have been more looked at as Finley's motive,
right,
than the actual perpetrator.
Exactly. That's exactly right.
So what we have in these statements, there is undated notes regarding Ron Haas. He was the HEB manager. And basically, in addition to corroborating Stacey's work schedule and her work habits and the fact that she was a reliable, conscientious employee, he says he heard rumors at HEB that Reed knew Stacey and would visit her at HEB. Andrew Cardenas might have mentioned that Reed and Stacey were acquaintances, so he thinks he heard about this from Andrew Cardenas. This is not saying he knew Reed and Stacey were seeing each other or that Reed visited Stacey at HEB. He's saying he heard a rumor, aka hearsay.
Right.
Then they go and they interview Andrew Cardenas. And in Andrew Cardenas's interview, again, the summary is undated, but it says that Jose Coronado said he had seen Reed talking to Stacey at HEB, and Cardenas had gotten the impression from Coronado that Reed and Stacey knew each other. Cardenas denied seeing Reed in the store or speaking with Stacey about Reed. So, again, hearsay from Coronado and Cardenas's impression based on what Coronado told him, neither of which is admissible evidence. And Cardenas actually denying seeing Reed in the store or speaking with Stacey about Reed. So, no direct knowledge from Cardenas. And then finally, the summary is dated 4/22/98 of Jose Coronado. And he denied telling anyone that Reed came into HEB and visited Stacey. And then he denied that he had ever seen Reed come into HEB to visit Stacey. So the source of the statements from Haas and Cardenas denies ever making any such statements.
Right.
Now, and Andrew McCrae's argument is that an investigator could make something of these things.
What does that mean?
It means an investigator could finally find somebody that would say they told Jose Coronado.
Right. Exactly.
About Reed and Stacey. And, extrapolating again, I think the witnesses that appeared on behalf of Reed, I think that over the years they've come to believe what they testified to as having happened, but it never happened.
Well, and I mean, again, for the audience, I'm just completely speculating, but applying Occam's razor, you have a small town. She has a quote unquote public position in a grocery store. That doesn't mean that somebody didn't say, oh, there's a cute girl walking, working at HEB. I'm going to go in and talk to her, ask her out. They might, it's not beyond the pale of conversation. They ever had a conversation before, but that's a big stretch between they had a conversation or maybe he had a couple of conversations with her. Again, I'm just speculating, but there's a big jump between having a conversation and having this, long-term affair.
Right. Exactly. And, I have always disbelieved it also because when would Stacey, that he says that he would meet up with her before she went to work. I think when he says that, he has no idea when she went to work.
Exactly.
And her habit and routine, which they claim came from Jimmy Finley, but in reality, came from Jimmy Finley and was corroborated by her mother and corroborated by her coworkers.
Well, again, let's apply Occam's razor. You get up early because you're working early to get extra money. And I apologize. I forget the specific time, but let's say her shift starts at 4 a.m.
Mm-hmm.
She's going to say, oh, Jimmy, I'm leaving. Why are you leaving at 2 a.m. to go to work at 4 a.m. when it's a 30-minute drive? Oh, I'm going to go see my boyfriend and have a passionate affair before I go into work. I mean, It's a little bit of common sense that she's not going to get up and allow, how is she going to explain why she's leaving an hour early for work?
Correct.
Especially at that time of night. It's not like she said, oh yeah, my shift starts at 11. I'm going to go in, grab some lunch. I love this hot dog place there in Bastrop. I want to stop and get lunch, and then I'm going to go into work. As Mom always said, nothing good happens after, 2 a.m.
Yeah.
There's really no reasonable reason for her to be leaving for work significantly early to go meet Rodney. Somebody would have had a question like, why are you leaving so early? It just doesn't make any sense. It just doesn't pass the sniff test.
Exactly. And leaving in time, with just enough time. And her habit was leaving with just enough time to drive and pull into the Bastrop parking lot. And good reason. She didn't want to be out at that time of night wandering around Bastrop.
Right.
I mean, when she got to the HEB before Andrew Cardenas, she sat in the truck, locked doors, waiting for Andrew. And when Andrew got there, they would walk in together. So she would not be meeting with Rodney Reed because she would be late for work.
Exactly.
Every time she met him before work, she'd been late. And
exactly.
Andrew Cardenas said she usually meet him there. That when he pulled up, he would see her truck in the driveway. And it was unusual on April 23rd that her truck wasn't already there. So now there was a second disclosure letter dealing with statements made by Suzanne Hugan to the post-conviction investigator who was probably interviewing her because her name had appeared on a witness list for Reed, and she had provided Reed's counsel with an affidavit. And in that letter, it doesn't include notes or anything like that. The letter basically summarizes that she told the investigator she saw Reed and Stacey at the store on one occasion a week before Stacey's murder. She said Stacey introduced Reed as a good or close friend, and they appeared to be friendly, giggling, and flirting. Reed was with another man who was friends with the son of a woman who worked in the photo lab, and Reed was friends with the son as well. It's kind of like Elizabeth Keener, or maybe it was Mella Marie Aldridge, Spanish girl that lived in the projects named Rose, that Stacey was supposedly best friends with. Little detail, extra detail. Hugan went on to say she didn't believe Stacey would have locked her seatbelt in the way it was found. She believes she told a man working security named Paul about this information. She described him as short, skinny, wearing glasses, with salt and pepper hair, and said he may have worked for the police department. She said it was possibly Paul Alexander, but she was not sure. So once again, we of course have statements that are consistent with the testimony that she subsequently gave at the hearing. But the defense is portraying her statement about Paul as being proven that she told Paul Alexander this information, when in reality, she's not sure if the person she told was Paul Alexander. So this is the creative writing skills of the defense that I have mentioned to you earlier today.
Right.
So, because they take what is said and they extrapolate. And Reed's counsel is notorious for doing this, as we'll see when we get into the claims about recantations of certain testimony. So that's basically, those are the state's 2021 disclosures. Frankly, none of it really helps Reed, because first of all, none of it's material. The statements from Haas and Cardenas are based on hearsay and therefore would not have been admissible at trial. So they can't say that those statements would have changed the outcome of the trial. And Jose Coronado denies telling anybody that Reed knew Stacey, visited Stacey, and Coronado says he never saw Reed come into HEB to visit Stacey. So he contradicts Reed's position. That's not going to help Reed.
Right.
So when we talk more about the objections and the 11th writ, we'll talk about this in a little bit more depth. But yeah, these are the disclosures. I find it to be much ado about nothing, because it doesn't really help Reed.
Right. Can you talk a little bit more? I don't know. What's the issue of the seat belt? That seems like a strange detail. Do you have any more detail on that?
Well, the seatbelt was found engaged, and it appeared that the person who had last driven the truck, who coincidentally moved the seat back too far for either Stacey or Jimmy Finley to have operated the truck, sat on the seatbelt, leaving it latched.
Right.
The theory at trial, based on Wilson Young and Karen Blakely's, experimentation, was that Karen Blakely, in the truck with the seatbelt engaged, she was about Stacey's size. Wilson Young was able to pull her out of the seatbelt from both the driver and passenger sides of the truck, leaving the seatbelt engaged. And then when Wilson Young got in the truck, he's 6'2", and guess what? The position of the seat was perfect for him. So circumstantial, but pretty strong circumstances in my mind, especially given that neither Jimmy Finley nor Stacey Stites were 6'2", but Rodney Reed was.
Right. And that's also something that somebody who probably doesn't drive frequently might do.
Correct.
Those are the little things that make you think, okay, this is somebody who probably, I mean, again, if we chase the rabbit into, it was Finley. Well, if it's Finley's truck, he's going to be very familiar with it, familiar with the seatbelt, likely is going to pop it off, put it on, not to mention he's a policeman, probably used to wearing his seatbelt. But to me, the fact that it's engaged speaks of somebody who plopped in, who doesn't drive all the time, especially it's an unfamiliar vehicle.
Correct. Or
maybe
again,
doesn't want to get a fingerprint on the seatbelt,
exactly.
locking device.
Now, Kevin Gannon has argued that the only people who drive with seatbelts like that are cops. While they will drive with their seatbelt like that in their patrol vehicles, they don't do it in their personal vehicles. I have known one officer who did that in his personal vehicle, and then he was going through a green light and a car pulled in front of him. He hit the car and he went forward and struck his head and severely injured himself on a windshield. And he stopped doing that in his personal vehicle. They do it in the patrol vehicles because you have to be able to get out quick.
To jump out quick, right.
But I also know of an officer who crashed his patrol vehicle and regretted not wearing his seatbelt because he was injured in a way that he would not have been injured had he been wearing the seatbelt. But there's kind of like, there's a no way around it.
Right. Understand.
But like I said, I haven't known any police officers who personally, especially when there's a seatbelt law, who don't do it in their personal vehicles or that do that in their personal vehicles.
Right. Well, and especially you were going to have the seat pulled that far back.
And, Reed's counsel has had multiple opportunities to ask Jimmy Finley about his habits as far as the seatbelt in his truck went. And they never have asked him.
Well, and think about the consistency, right? If you're going to follow the same pattern that you normally do. So if we said hypothetically, Jimmy Finley is doing what he normally does in his truck, and let's just, again, this is pure speculation. Let's say he doesn't use his seatbelt. Well, it would only be consistent then. He's also not going to pull the seat back. If he's driving the truck the way he always does, which is the argument for the seatbelt being engaged, then he's not going to pull it back for someone that's, 6'2". He's going to either, it's going to be consistent or it's not. I don't think he's a criminal mastermind that's going to do, I'm going to do this one way, but I'm playing chess over here. I'm going to really trick him by doing this. So it just doesn't make any sense that it wouldn't be consistent.
And I've always argued if he intended to frame Rodney Reed from the moment he supposedly killed Stacey, why would he not once mention Rodney Reed's name?
Exactly. Why wouldn't you say, hey, I think my my fiance is having an affair. She always leaves early. She's probably meeting this guy and his name is Rodney Reed. Exactly. That would be the first thing to do to sort of cast suspicion on somebody else.
Right. So, all right. So now we get to the proposed findings and conclusions, which were submitted by Reed and the state. And I'm not going to go into detail on either side, but I think a little comparison is helpful.
Yeah, and Lisa, before you jump in, could you maybe give, for some of the audience that aren't maybe legal experts, could you talk a little bit about, why does it seem like Reed is being afforded the opportunity to basically relitigate this trial through the appeals process? I think for a lot of lay people, it feels like Reed is basically attempting to reintroduce things that were available in 1996 and effectively relitigate the trial through the appeals process as opposed to, appealing things that already were in the record of the trial. There hasn't been any really new evidence or new technology, just, why is he being allowed to sort of go back and redo things that were available to his counsel back when he was originally tried?
Well, I think part of it is the creative skills of the Innocence Project in crafting their writs in a way that makes it seem like there is strong evidence that Rodney Reed was wrongfully convicted because evidence was withheld, or because that there is evidence of his actual innocence that was not presented to at his trial that would have changed the outcome of his trial. And what happens is they're able to craft these writ applications in a way that results in either a stay for more time to analyze what's being presented by the Court of Criminal Appeals, or a stay to remand the case back to the trial court to have an evidentiary hearing to develop these claims. And what happens, and what has happened throughout the course of the post-conviction litigation on Reed's behalf, has been that at these evidentiary hearings, the evidence has not been reliable or credible. The relationship evidence that he presented, the time of death evidence that he's presented, none of that has been sufficient to enable the trial judge or the Court of Criminal Appeals to say that would have changed the outcome of the trial. So he ends up not succeeding, but it buys him time.
Right. Because none of these things that he's claiming, this is not like there's a new technology development or new witnesses. These are all things that, for all intents and purposes, were available back during the original trial. He could have called these witnesses. He could have talked about the affair. He could have given specifics about when and where they met and, very specific things. None of this feels new, but just going back and sort of relitigating something that he had every opportunity to do during the original trial.
Correct. But these witnesses, for example, the HEB witnesses that confirmed the affair and or contradicted Jimmy Finley's testimony about his relationship with Stacey by claiming to have witnessed abuse or aggressive behavior or belligerent behavior toward Stacey by Jimmy, or the people who claim to have heard inculpatory statements from Jimmy, it was presented as very strong evidence. And it was presented as new evidence, even though the HEB employees arguably are not new. They're not talking about things that happened post 1996. They're talking about things that happened at the time or before Stacey died. But they were presented as new, and they were argued. I think Reed's argument was basically the police should have found these people and didn't. And if they had, or the police did find these people and they withheld it from Rodney Reed's defense attorneys. Because, Fletcher, Derleth, and Clampett were all presented as Brady violations. Law enforcement officers who possessed exculpatory information that was not provided to Reed's counsel. And I think something that people on the pro-innocent side and family members of victims don't see is that due process doesn't require that they present a strong case and present the merits in their application. It only requires that they present enough information to enable the court to decide that it needs to be developed further.
Well, and I think this is a good time to sort of remind folks that are sympathetic to Reed, as we've discussed, he's not an unsophisticated person. He has been on trial before and was acquitted in a very similar situation. Why did he not talk to his counsel and say, I went with Stacey to her work. I talked to people. I may not remember their names, but let's go interview everyone at HEB. I'll go with you, or I'll, go talk to them because I spoke to a young white girl who worked in the produce department and Stacey introduced us. His defense counsel could have asked these questions back then as well. He could have told them about some of the folks that he talked to and met at HEB, again, according to some of these statements from these witnesses that say, he was introduced and went to HEB a lot and saw her and talked to her.
Correct. And according to interviews given by Jimmy Brown and Lydia Clay Jackson, at least, they did do that. And they did find HEB employees who corroborated everything Rodney Reed had told them. One of the difficulties in the Reed case, especially, is there's a disconnect between the legal avenues being pursued by Innocence Project and the social media campaign being waged by Reed's minions. So when you question, well, why didn't his defense attorneys call Suzanne Hugan, Brenda Dickinson? Why didn't they talk to these people? You get racism and or the attorneys work for the state and we're trying to get Reed convicted. Even though Reed has never, he's made kind of weak, ineffective assistance claims, but he's never really pursued those claims. And in fact, this is the first hearing that Garvey and Clay Jackson have not been called by Reed's counsel to support his claims in the hearing. Because they've been more than happy to come in and say, we got too much information and we weren't able to adequately process it and we didn't have enough time and we asked for more time and the judge wouldn't give it to us. And I was just appointed in January of 1998 and we went to trial in May and it was not fair. And, all these complaints, and they've supported him all these years. So they're not making the allegations of ineffective assistance that they should have been making all along. And now it's too late. They can't turn around now and start saying ineffective assistance of counsel because they could have said that in his first writ and they didn't.
Right.
So, so that was a great question. Thank you for asking it.
Of course.
And
a great answer.
So thank you. Let's talk about Reed's proposed findings that he submitted. The one thing that stands out to me is that it was a lot. There were 153 pages. Reed had 887 paragraphs of proposed findings and conclusions. Now, some of those things were taken up in procedural history and the remand history. So let's say 1 to 42 was procedural and remand, and the evidence presented. So let's go with his total was like 845 proposed findings and conclusions. That's a lot.
Yeah, and for the how would that, like, what would you say? And I know it's tough to say, but if you would say quote unquote normal average, what would that number be? How does that compare? Like, how would you benchmark that against, again, quote unquote normal?
Well, I mean, I would say an average would be maybe 200 factual and 50 to 60 conclusions of law. And, I didn't go into this, but really, like the peer review report authored by Innocence Project and signed by Dr. Greg Davis, most of these findings and conclusions were argument. They weren't, they were argument. They were trying to get the court to say that Reed had proven everything he set out to prove at the evidentiary hearing. And one of the other interesting things was when they discussed fennel, that was paragraphs 553 to 618. That's over 50 paragraphs. think it's like 65 paragraphs just on Fennell.
Wow.
And most of it, the gist of it was Reed's witnesses were credible. You should believe them. Bastrop Police Department, Texas Rangers, Bastrop City Police did a horrible job investigating this case. Should have found these witnesses and didn't. And Rodney Reed needs a new trial. That's the gist of their findings and conclusions.
And Lisa, apologize. Another basic question again, thinking of folks that may not be as familiar with the case, was Jimmy Finley considered an alternative suspect to the same degree at the time back during the original trial, or is that all something that largely emerged after he had his own difficulties with the law and his own rape conviction?
He was considered an alternate suspect at the trial. However, Lydia Clay Jackson claimed during the 2017 hearing that she wasn't provided with enough information about him to, quote unquote, take the gloves off. So she handled him with kid gloves in her questioning. Now, one of the things I've always wondered, and I've wished that someone would ask her, is when you talk to your client, did he tell you that Jimmy Finley threatened him one night? Because that came up during post-conviction litigation through Chris Aldridge's statement. Did he ever tell you about that? No. He was there. And a lot of the things that you and I have kind of alluded to, a lot of these HEB witnesses, Rodney Reed should have told Lydia Clay Jackson to go find these witnesses and bring them in. Now, Lydia Clay Jackson says she found them. They did agree and they did, give her good information. But then either HEB or cops, she never precisely identifies who, intimidated the witnesses to keep them from testifying on behalf of Rodney Reed. But
even
I would have liked a state's attorney to inquire into, get more detail on that situation as well. And I would have been, had I been a state's attorney, I would have said to Suzanne, did you talk to Reed's defense attorneys? Did somebody at HEB tell you not to talk to the defense attorneys? Did the Bastrop police tell you not to talk to defense attorneys?
Right. Well, and similarly, wouldn't have Stacey, if Rodney and Stacey are so close and they're having this wonderful affair, wouldn't have she told him how abusive and terrible Jimmy was? Wouldn't that have been something she would have shared with him?
I would expect that would have been something she would have shared, that he could have shared with the attorney, and his attorneys could have developed that information.
Exactly.
I mean, Dwayne, the stuff about Brent Sappington and William Sappington and hearing the furniture being thrown around and the arguments in the apartment above Bill Sappington. Why didn't Dwayne only go to Rolling Hills and interview the tenants about Stacey and Jimmy?
Exactly.
Because he could have developed all this information.
Exactly.
But I think the information really took hold and took center stage, or pointing the finger at Jimmy Finley really took center stage when he kidnapped and raped Connie in Georgetown in 2007.
That's always been my impression, again, not knowing this case nearly to the detail you are, is that after he was convicted of that horrible crime, which no one doubts that he did, then suddenly that was retrospectively read into 1995, 1996, all of these things that happened prior to her murder. And everybody sort of looked back on that and said, oh, okay, now let's go recreate this theory that Finley did it, which at the time obviously did not, there was no clear case or evidence as him as a viable suspect at the time. It was only sort of through that crystal ball that it was read. All these events of later on were read back into what happened in 1995 and 6.
Correct. At trial, he was one of many, because the
Right.
alternate suspects at trial were Jimmy Finley, David Lawhon, and an unidentified dark-skinned black male. Now, this unidentified dark-skinned male, well, Rodney Reed's dark-skinned. So, but the witnesses who claimed to have seen the dark-skinned male said it wasn't Rodney Reed. But that one has always just kind of made me scratch my head, because, you know, the witnesses claimed to have seen this dark-skinned male with Stacey that night, but it wasn't Rodney Reed. So, and there's something that I've said before, and I'll say it again. If a person came forward now and said, I was in Bastrop on April 23rd, 1996, and I saw Rodney Reed getting out of a red pickup truck in the high school parking lot. You know, I know Rodney Reed from high school, or I know Rodney Reed from town. I saw him getting out of this red truck in the high school parking lot. Or I saw him standing outside a red truck talking on the phone at Long's. Or I saw him driving on 1442 in a red truck. That witness coming forth 26 years later would be branded a liar.
Right.
And unless something corroborated that witness's statements, their failure to go to police in 1996 would be a huge feature in the diatribes attacking their credibility.
Exactly. That's 100%. There's always the double standard applied.
If a person comes forward saying, I saw Jimmy Finley on 1442, or Jimmy Finley confessed, or Jimmy Finley said she got what she deserved, then not coming forward in 1996 is okay.
Exactly.
And we'll talk about that a little bit more later. So yeah, Reed's proposed findings were a bit excessive, and they were mostly argumentative. And I think this is because deep in their hearts, what little black that remains, shriveled and 2 sizes too small, they know they're not going to win in court. So they're going to play to the court of public opinion.
Right.
And then when Rodney Reed's up for clemency or commutation or whatever system is available in Texas, that people will write and say, pardon him, he's innocent. I don't think they're going to have the luck that Julius Jones's people had in Oklahoma, but you never know. And the state's proposed findings and conclusions were more reasonable. Let's put it that way. They were basically, it was 35 pages total. The proposed findings took 32 pages. There was a proposed order denying relief on page 33, and then a certificate of service included on 34 to 35. Their findings were 190 paragraphs of proposed factual conclusions for the judge and 33 paragraphs of proposed legal conclusions. Now, in Texas post-conviction, submitting proposed findings to the judge is actually a common practice, as is the judge accepting one over the other and signing one over the other. The judge does have the option of rewriting and reorganizing, but he doesn't have to. So there's nothing nefarious about this as portrayed by later complaints by Innocence Project. And in my review, it appears that Judge Langley did make some changes, because the ultimate document entered is not exactly identical to the findings proposed by the state, or the pleading submitted by the state. So, and like I said, this was more in line with what I would expect from a hearing with as many witnesses over, was it 9 or 10 days?
I think that's right.
So, and basically the key thing for Judge Langley to decide in this case was the credibility and reliability of the witnesses and the testimony being offered by them, whether it was Reed's witnesses or the state's witnesses. That was the key. And so the state's proposed findings were more in line, as I said, with what I would expect proposed findings to be. And, it gives you an idea. I summarized the state's proposed findings in 2 pages, and it took me 9 pages for Reed's.
Well, and it's important to sort of double click on what you said earlier. There does seem to be a movement in some of these high profile cases to seek to just overwhelm, the courts, and then just, again, present this, instead of trying it in the legal system, trying in the court of public opinion through social media, again, to hope that sort of organically those people that, fight these things online, exert enough pressure to, have an influence on the justice system, even if it's, sort of outside of the appropriate legal processes.
Correct. All right, so we're at the meat and potatoes, the findings of fact and conclusions of law issued by Judge J.D. Langley on October 31st, 2021. His proposed findings were 50 pages. Or that's not, I shouldn't say proposed, I should say his findings were 50 pages. Because, that's where copy and paste gets me. And there were 189 paragraphs of factual conclusions and 38 paragraphs of legal conclusions. Now, paragraphs 1 through 16 were not contained in the state's proposed findings. And that is a summary of the facts developed at trial and in some post-conviction or early post-conviction that was taken from the ex parte Reed 2008 third writ opinion issued by the Court of Criminal Appeals. And then he, does a summary of the procedural history and the grounds raised by Reed and those remanded by the Court of Criminal Appeals, which were ground 1 was suppression of evidence. That was the Brady violation, where he cited Reed's allegations. I didn't include those because that's him citing the allegation. That's not him adopting the allegations. And I didn't want to confuse myself with having those allegations looking like they're his findings. So that's where you have some paragraph number allegation that tells you nothing. I know. So let's go through. I want to go through these witnesses one by one because I think it's very important to understand the judge's reasoning with each of these witnesses. The first one was Richard Derleth, who was not called to testify. He submitted an affidavit in support of Reed's 10th writ, but for whatever reason, they did not call him to testify. This led to a negative credibility determination because Durleth's statements were not specific recollections about the alert system. He was referring to hearsay from unidentified HEB employees that there was an alert system in place. Interestingly enough, the first mention of this alert system was from Leroy Ybarra, who provided an affidavit in 2014. And I'm going to tell you, I'm speculating, but this is what I believe. When these interviewers, when these investigators talk to the HEB employees, they say, we heard there was an alert system. When Jimmy came in the store, y'all would tell Stacey to go hide in the back. Is that true? And so, of course, the witnesses wanting to help say, yeah, that was true. That we did. That was true. So, Durleth's affidavit was not believed. He also was not part of the investigation. So his information could not have been suppressed because he wasn't part of the investigation. Fletcher, he testified that he saw Jimmy and Stacey fighting the weekend before Stacey was murdered, or very close to it, and that Fennell told him that Stacey was having an affair with an N-word, or effing an N-word. The judge made a negative credibility determination about Fletcher and his testimony. His recollection was suspect because it was from decades ago and conflicted with the testimony of his ex-wife, Etta Wiley. The judge found that despite Fletcher's gut feeling about Fennell's behavior at the funeral or the burial, he didn't say anything about his suspicions or his interactions with Fennell to investigators. The judge also found that Fletcher added Curtis Davis at this barbecue in his testimony, but failed to mention his presence in the affidavit. And by that time, Curtis Davis was dead. He also admitted on the stand, he was not involved in the investigation, and he admitted that his current wife's research into the case had influenced him to come forward. The judge also found that his testimony was suspect because one of the things he cited as a reason for not coming forward was the conspiracy theories about the death of Ed Salmella. The judge ultimately did not believe that Fennell told Fletcher about a supposed affair with a black man. He didn't believe Fletcher's recollection that Fennell and Stacey were fighting. He put no stock in Fletcher's claim that Fennell behaved oddly at the funeral or the burial. And he found Fennell to be more credible than Fletcher, where Fletcher and Fennell's testimonies differed. And he found Fletcher was not credible. Jim Clampett came forward in 2019. He was a former Lee County Sheriff's deputy. He was also a former fish or wildlife officer with the state of Texas Department of Public Safety, I believe. There was a negative, once again, credibility determination regarding Clampett because he waited decades to bring forth his recollection. And as a peace officer, he didn't ensure that investigators on Stacey's case or those handling it post-conviction knew of this recollection. Were you about to ask a question?
No, I was just going to say, I mean, we continue to see these themes of these witnesses being told shocking statements at the time, and especially when they're peace officers. But they obviously were not shocking in 1998 because they didn't think it was worthy to come forward. But then oddly, 20 years later, they have this perfect, recollection of these shocking statements that they decide become important, all these years later.
Correct. That one is, and when we talk about the closing arguments, we'll talk a little bit more about Reed's attorney's justification for this. because in their testimony, none of them really offered anything beyond, well, I didn't know it was important. And we'll talk about that a little bit more later too. So with the negative credibility determination there was a second negative credibility determination as to Clampett made by Judge Langley because he had improperly testified for a friend while in uniform and was found by DPS or Wildlife and Fisheries. I can't remember what the department is called, even though I watch Lone Star Law every week, to have committed perjury. And he resigned from his job as game warden as a result of that black mark on his record, which I guess he didn't tell Reed's counsel about. Because,
of course he didn't.
And I'm sure they believed that they were sandbagged when that part of the cross-examination started. Judge Langley also found Clampett's recollection suspect because it was from decades ago, and he admitted his memory is not as clear as it should be. He also found the testimony suspect because Clampett has paid attention to the publicity, and he testified that influenced his decision to come forward. Clampett also was not involved in the investigation and told no one involved in the investigation about his recollection, which impacts his credibility. And the judge found his testimony suspect because he didn't think the statement, which he said shocked him, was important in 1996, and he didn't come forward until 2019 when there was some significant media coverage about the case. Judge Langley went on to specifically find that the Lee County Sheriff's Office had no involvement in the investigation, as Clampett admitted and as testified to by Rocky Wardlow. Finally, Langley found Fennell more credible where Clampett and Fennell's testimonies differed, and he found that Clampett was not credible. The state raised what is called a laches defense, and is basically saying that the claims were presented too late for the state to be able to adequately address them because a lot of evidence that would have addressed them is gone, or people with knowledge have passed away or cannot testify. And so as to laches defense, the judge made specific factual findings that John Barton had passed away, Ronnie Duncan had dementia, Paul Alexander had passed away, Roberto Bayardo had dementia, Curtis Davis Jr. passed away, Suzanne Byers, who I believe was a co-worker at HEB, had passed away, Michael Kirby, who worked with Stacy at Covert, had passed away, Karen Woodward, who had done a sex assault examination, had passed away. Deborah Davis's testimony regarding deterioration of memory over time, and that it can be influenced by and distorted by pre-event bias and post-event information exposure. He found her testimony to be credible. He found that the CCA has found Reed has abused the writ on numerous occasions. He found that the CCA has described Reed's post-conviction litigation tactics as a piecemeal approach. He found that the CCA had found that Reed's request for DNA testing was made to unreasonably delay the execution of his sentence or the administration of justice. And for those who aren't familiar, Reed filed a request for DNA testing just prior to a hearing on the state's motion to set his execution date, which was filed in 2014. He could have requested DNA testing in 2011. He could have requested DNA testing in 2009. He could have requested DNA testing in 2013, but he waited until his federal writs had been fully and finally decided. And then when the state sought an execution date, he brought in litigation regarding DNA testing, which I think was one of the reasons his execution in 2015 was ultimately stayed because he was challenging the denial of DNA testing by the trial court at the CCA.
And Lisa, do you think, is a lot of this stuff done very intentionally, meaning both those two things? If you talk about the latches, I'm not sure if that's the defense, what the right way to use that term, but is it common in a lot of these cases to say, hey, it's been 20 years. If we can just find 3 or 4 people that'll say what we want them to say from the defense, there's really not going to be a lot of people that have been thinking about this case over the last 20 years. They've passed away. Is that a common tactic? Because just knowing that really most people have forgotten or again are no longer available to testify. And similarly, the timing, I'm assuming it's a lot easier to get some press and publicity about DNA testing around a potential execution date as opposed to just, when there's no sort of dramatic execution where a man's life hangs in the balance to be attached to that from a publicity perspective.
I think to a degree, I don't think they're specifically waiting for people to pass away and then trying to raise issues. But I think that they are. I think in Reed's case, they're actually what they're doing is what they did, and I think they've stopped because it has bitten them in the ass one too many times. What they were doing was they were pursuing one avenue. And then when that failed, they were bringing a second one and a third one. And so what happened was they pursued, while his case was on direct appeal, they filed a state post-conviction writ alleging a Brady violation based on the beer cans. And then while that was pending and the direct appeal was still pending, they filed a second state writ. And when those were unsuccessful, they filed a third state writ with allegedly new evidence. That was Martha Barnett and Mary Blackwell. So, and then with the federal writ, they went through the federal process, and that was unsuccessful. So then they asked for DNA testing when the state wants to set an execution date. So instead of pursuing everything that they can possibly pursue contemporaneously, they save it and do it consecutively.
Got it.
Or concurrently. They wait and do it consecutively. Now, they're no longer doing that. Okay? They're not waiting to file the 11th writ while the CCA is mulling over the 10th writ. They're filing it now and getting that process started. They also filed the 7th, 8th, and 9th writs while, they filed the 8th and 9th writs while the 7th writ was still pending. They filed the 9th writ right after the 8th writ had been denied at the trial court level, but it hadn't been decided by the CCA yet. So, and they're pursuing the federal DNA case in the Supreme Court now, contemporaneously or concurrently with all this other stuff. But initially they were doing it piecemeal. They were doing consecutive instead of concurrent. But they're still using the, shotgun spaghetti method of throw it all at the wall and see what sticks.
Exactly.
So, the next finding was the Fifth Circuit has found that Reed's post-judgment district court submissions were untimely. And that was when he submitted Bayardo's affidavit, quote, recanting, unquote, his trial testimony or time of death and placement of semen after the federal district court had denied his relief on his federal writ. The judge found that most of the evidence for Reed's 7th, 8th, 9th, and 10th applications has come about at or around the time of his execution settings in March 2015 and November 2019. He's found the 7th application was filed in February 2015, little more than 2 weeks before his execution date. The 8th application was filed in June 2016, a little more than a year after the March 2015 execution setting. The 9th application was filed in June 2018, a little more than 3 years after March 2015 execution setting. The 10th application was filed in November 2019, 1 week before his execution setting. And again, they claim they just discovered these witnesses in October of 2019. But why didn't they discover these witnesses in, 2015? Because they were looking for witnesses in 2015 or 2014, because that's when they had Leroy Ybarra, Alicia Slater, and Calvin Horton attesting to the relationship.
Right.
So ground 2 raised by Reed that was remanded was the use of false testimony, unknowing use of false testimony by the state at trial. The factual conclusions made by the court are that Fennell was credible and his testimony was given the full and proper weight by Judge Langley. Now, this is not the outcome Rodney Reed wanted. Rodney Reed wanted his witnesses to be found to be credible and Fennell to have been found to be the liar. So this is the first nail in Rodney Reed's coffin as to the 10th state writ. The judge credited Fennell's testimony that he was offered nothing by the state in return for his testimony, and he was not testifying expecting any benefit. The court found that Stacey and Fennell were happy together, excited about their wedding, and planning for their future together. It found his account of April 22nd, 1996 and April 23rd to be credible, where his testimony at the hearing materially differed from the trial. He found that Fennell's memory was better 25 years ago. He found that Fennell closed his bank account because of the missing checkbook, which again is not what Reed's counsel wanted. They wanted the judge to draw a negative inference. And I think David Fisher is alleging that when he first took Carol's keys at 6 o'clock or 7 o'clock in the morning, that he immediately went to the bank and closed the account. But the bank probably was not open at that time. So, where Fisher gets this crap, I don't freaking know. He also found that Fennell gave credible testimony about the emotional loss caused by Stacey's death and his testimony that he was taking Xanax, which was corroborated by Thelma Fennell and Mark Brown. And he also found Jimmy credible when he testified that Xanax made him feel numb and created a flat effect. He found that Fennell was considered the prime suspect and treated as such during the initial investigation. He credited Fennell's testimony that he failed the polygraph test due to feeling responsible for Stacey's murder because he didn't drive her to work and failed to protect her. He found that in 2008, Fennell pled guilty to improper sexual contact with a person in custody and in prison devoted his life to the Christian faith, earning a bachelor's in ministry and a master's in theology while he was in prison. He found that Reed's sexual assaults are closer in temporal proximity, and as to Vivian H. and Linda S., those more closely resemble the facts of Stacey's murder. He found that they would carry greater weight than Fennell's crime, which was committed over 10 years later.
Yeah, those two things, it's funny, we always laugh about sort of the double standards and the inconsistency, both with the polygraph and with, Fennell's sexual assault. The Reed supporters will suddenly now polygraphs are absolutely critical and must be carry the weight of 100% truth. And because, Fennell acknowledged that he created a sexual assault 10 years later. But again, they completely ignore Reed's history of doing crimes that were basically exactly like what happened to Stacey.
Correct. And, you know, it's funny. I saw on Twitter a Reed minion, who shall go remain nameless, who has actually criticized somebody for not calling Fennell a serial rapist. But Fennell's only been convicted of a single rape. You know,
Exactly.
He's allegedly been accused, although he isn't actually accused of rapes. He's accused of improper, inappropriate dealings with women while in uniform. None of the women claim he sexually assaulted them. I think there was one other woman. Take that back. There was one other woman who claimed a sexual assault. He was never charged. He was never tried. He was never convicted. So, again, if you have to call Jimmy Finley a serial rapist because he was convicted of one rape and has been accused of multiple others in that minion's mind, then we've got credible allegations against Rodney Reed of multiple rapes. He's been convicted of one rape, and that he's been convicted of Stacey Stites' rape and murder. Therefore, he should be called a serial rapist. He can be called a serial rapist.
Right.
But that's not how their little minion brains work. So, and they have yet to explain the distinction. Jimmy's never been tried. He's never been charged. He's never been convicted of these other allegations. By their reasoning with Reed, therefore, allegations do not exist.
Exactly.
They didn't happen. So
there's always a double standard depending on what side of the fence they're on.
And I'm still waiting on one of these minions to logically and reasonably explain why Rodney Reed gets a pass and Jimmy Finley doesn't. When the situations are nearly identical.
Right. Yeah, there's no logic to it, so you'll never get a rational, logical answer.
I know, but I can hope, I can dream. I can wish for a unicorn to fly through the room, squirting glitter out of its ass.
I'm not going to be able to unsee that analogy.
Yeah, I know. That might be our new logo.
Yeah, exactly.
All right. Factual conclusions on Fennell. Number 64. We're at 64 on Judge Langley's findings. Fennell elected not to testify under the Fifth Amendment in 2017 on the advice of counsel because he was still serving his prison sentence and the stress affected his ability to remember. The court found that since leaving prison, Fennell continues to serve the Christian faith as an ordained minister, a minister at his church, and through a recovery program called Celebrate Recovery. So the court had very positive made very positive findings and conclusions as to Jimmy Fennell's testimony. The court also credited Fennell's testimony that he didn't work at SPJST after 1994 and that he did not threaten Stacey in front of Volek. Fennell and Stacey did not socialize much, and Fletcher did not visit their apartment, and he never told Fletcher that he knew about Stacey's affair with a black person. He didn't speak to Gary Joe Bryant in a threatening manner or intimate that he knew about Stacey having an affair. Stacey and Fennell never had the type of public arguments described by some witnesses, including Scroggins, Espinosa, Hugan, and Dickinson. Fennell did not say at least the bitch got to wear the dress. Fennell did not say she got what she deserved. The judge found that Snow was not credible. Fennell was not in the Aryan Brotherhood. He did not confess that he killed Stacey or confessed to knowledge of an affair with Reed. Fennell had friends of all races in prison, which cuts against alleged Aryan Brotherhood membership. The judge found that Bordelon was not credible. Fennell did not confess to him, did not know Bordelon, or that Fennell had knowledge of an affair with Reed. Fennell's relationship with Stacey was good, with occasional arguments. Fennell did not know Reed and did not know of Reed prior to his arrest for Stacey's murder, and Fennell did not kill Stacey. So those are very strong findings of fact. And I think they are entirely supported by the record and Fennell's testimony and the credibility issues of the Reed witnesses. So I think in the long run, I think the Court of Criminal Appeals is going to not have a problem endorsing Judge Langley's findings as to Fennell.
Yeah, that seems very consistent. I mean, it's amazing that, the only people that seem to have negative things to say about him or their relationship were people that were kind of at an arm's length to it. You don't see her family or, people that were in their life paint a negative picture about him. It's all people that arguably were not close to them, or at least not intimate with them as a family member or a close friend would be.
Correct. I mean, Carol, they spent every minute they weren't working, they spent with Carol until they went up to bed.
And Stacey and Carol seemed very close. And I'm sure if he was abusive or she was afraid, she would have said something to her mom.
Yeah. And, I think I asked Deborah and Crystal point blank, if Fennell was abusive, what would Stacey have done? She said, leave. She wouldn't have put up with it.
Right.
Curtis Davis made an interesting statement too. He said that in the relationship, because Stacey was more exuberant and outgoing, Stacey seemed to be the one to wear the pants in the relationship. Right.
And is a case of most male-female relationships.
Stacey said jump and Fennell said yes, ma'am.
Exactly.
And the racist, aggressive, controlling person described by these witnesses, again, is not the one described by either Carol or Deborah or Crystal.
Right.
That just is not. Now, Stacey was younger, so as the older person in the relationship, yes, Fennell probably thought he knew better sometimes. And he may have tried to guide her toward what he felt was the better course of action based on his advanced age. But that's not controlling. And
exactly.
Again, the person that Crystal and Deborah describe would not have put up with a controlling relationship. Would have been like, look, buddy, when you are the only one working and you're the one paying the bills, I will carry your tune. But while I'm working and supporting us and contributing to our support, I'm going to make my own decisions. That's the impression I get of her. Right. It's entirely speculative on my part, but I don't think she would have put up with it. And, Tammy Hannah described how he wouldn't let her go out. Well, she was a homebody. Maybe she just didn't want to go out. And she used Fennell as an excuse.
Right.
And some of these other HEB people. And again, I question why these HEB people didn't tell anybody when Stacey was murdered how horrible and controlling and abusive Fennell was. It just doesn't make any sense. So going back to the findings, the judge kind of analyzed some of the other states' witnesses. He found Crystal Dorman, who is Fennell's sister, to be credible, and that All of her testimony was consistent with the statements she made to the Austin American Statesman on April 24th. Basically, they all testified about Fennell's extreme grief and their observations of his behavior at the funeral and at the burial and the viewing. And he credited all of them, found them all credible, and that their testimony corroborated Fennell's, and that, that basically refuted the testimony of Reed's witnesses. The court also found that Stacey's HEB new employee information sheet said going to get married on it, which does not paint the picture of a woman who's not excited about her marriage. Then it goes on with Ron Haas, who was the manager, Moreno, who was he attended a training seminar. So all he really testified was his encounter with Stacey over those 4 days and the fact that she was excited to get married. Sandy Sepulveda and Diantha Lee, they, each testified that they had run into Stacey and she was excited to get married. And he credited Deborah Davis's testimony regarding memory, its deterioration over time, and the ability for it to be influenced by pre-event bias, like, say, somebody who doesn't like Fennell or cops in general, and post-event information exposure. For example, an investigator saying, there was an alert system, tell me about it. Then Judge Langley went on to talk a little bit more about Reed's witnesses. Derleth, again, he made a negative credibility determination for the reasons, and any testimony Derleth may have offered for the reasons stated in ground one. He also found Clampett and Fletcher were not credible for the reasons stated in ground one. He found Ruby Volek to be inherently uncredible. The events that she testified to occurred 19 years before she came forward and 25 years before she testified. Her facts were discredited by Fennell's testimony regarding his employment at SPJST. And part of the reason for that is she specifically said he was working when he applied for this insurance, or when he and Stacey applied for this insurance. And he was working when, and Stacey would come hang out there. So that's how she knew Stacey. Well, if he wasn't working there in 1995 or 1996, then none of this could have happened. Now, there was an application for insurance made on behalf of Fennell and Stacey, but it doesn't necessarily have to have been made in with Fennell being employed at this, it's like a fraternal organization, I believe. He also discredited Volek's assumption that Fennell had made a serious threat. He found it speculative at best and inherently unreliable. And he also found that she did not come forward until she heard about Reed's execution in 2015. He found Snow not credible for the reasons he went on to state in ground 4, and same with Bordelon. So, again, Reed's witnesses did not pass the credibility tests. Basically, on some of these other HEB witnesses who testified to seeing Reed and Stacey together, or encounters with Fennell and Stacey, or witnessing encounters between Fennell and Stacey, again, he found them not credible either because some of their testimony was contradicted by other witnesses. For example, some witnesses testified that Stacey was afraid of Fennell finding out about her affair with Reed, and yet Randall and Hugan, I believe, testified that Stacey was openly chatting with Reed in HEB where everybody could see. And in one of the others said she put her hand on the small of his back in a very intimate gesture, which is inconsistent with her fear of getting caught.
Yeah, you're reading my mind. I was going to make that same comment. That's where a lot of these arguments, they break apart because they're internally inconsistent.
Mm-hmm.
She's having this secret affair where she has to get up early in the morning and meet Reed before work. And she's terrified of this, horribly brutal fiance that's going to kill her if she finds out. Yet that can't be true if she's just going to take Reed around HEB and flirt with him and talk about this is her friend Rodney. Just all these arguments, they're just internally inconsistent.
Mm-hmm. Yeah. And so basically he didn't find these people credible. And another huge factor in that negative credibility determination is their failure to come forward for over 20 years. And the fact that a lot of them saw something about the case on Dr. Phil or in the 2019 media articles, and that's when they made their decision to come forward. So he found Scroggins, who came forward actually during a prior writ, but was never called to testify. And Scroggins reached out to the media first, was put in touch with Bryce Benjet, and then signed an affidavit claiming to have seen Fennell screaming expletives at Stacey, and Stacey is trying to say, I work here, let's not do this. Scroggins has given, I think, inconsistent statements about where this happened. I think in some statements he said it was at the HEB, but in his testimony at trial, I believe he said it was somewhere else. He claims that he saw a picture of Fennell in 2005, which jogged his memory, but examinations of the Austin Chronicle, where he claims to have seen the picture, there was no picture of Fennell in the paper between 2001 and 2005. The first time his picture appeared was in 2008 or 2007 when he was being investigated for rape.
And again, that doesn't seem to make common sense that Fennell's going to drive, 35 miles to her work just to get into an argument. Yes, it's possible, but odds are he's just going to wait till he gets home.
And that's another problem that I have with a lot of these witnesses, the HEB witnesses, saying there's an alert system and claiming to have witnessed encounters between Stacey and Fennell in HEB. Fennell was a Giddings police officer. He was usually working at least toward the tail end of Stacey's shift. He was 35 miles away in Giddings. He was not in Bastrop, patrolling Bastrop, where he could just stop by any time.
Right.
If he was going to stop by, it was going to have to be a day off. And in Curtis Davis's interview with CNN, he said that they were actually, when Stacey started working in produce, they became two ships kind of passing in the night.
Right.
Because when he was working, she was at home sleeping. And when she was working, he was at home sleeping. Which, again, leads me to believe that there was not an opportunity for him to be dropping in the HEB at Bastrop very often. And I think these witnesses don't know. They see him as a Bastrop cop because the crime happened in Bastrop.
That's exactly right. And they're just like, oh, well, yeah, of course I saw him come in. But again, they're not thinking about, logically at the end of a long shift where he's been patrolling in Bastrop all day or in Giddings all day, he's just going to drive, 35 miles to Giddings just to go have a fight with Stacey while she's at work.
Right.
It just doesn't pass the common sense test.
When she was working as a cashier and kind of working regular store hours, there may have been times when he came to pick her up.
Right.
But once she started working in produce, that ceased.
Exactly.
And a lot of these statements about these encounters, they're not putting a time frame on it.
Exactly.
So we don't know whether it was when she was
specific.
cashier, right, or produce. And again, it would have helped if when Stacey was murdered, they went to police and said, "Oh my God,
Right.
this is what he
Exactly.
did."
Yeah, and that's the macro theme, is all of these statements are 20 years old and, influenced by whether it's Dr. Phil or the innocence for all of these. Oh, a poor man innocent man's about to get executed.
Right.
You can't separate those two things.
Now, on this particular set of findings of fact, the judge is kind of looking at state and Reed witnesses together. So he found Ted Weems to have been a credible witness. And he found Brent Sappington's testimony credible where it was corroborated by Weems. He found Sappington's testimony regarding his father having been told, "We've got our suspect. We don't need anyone's help. Mind your business. Hush your mouth," not to be credible. And interestingly enough, this suggests if William Sappington was told this by some Lee County authority, this suggests that he didn't go say anything until after Reed was arrested. Because if their suspect was Jimmy Finley, they would love to hear Will Sappington's account of frequent screaming arguments where he believes Jimmy Finley is abusing Stacey Stites in the apartment above him. The judge also found not credible Sappington's judgment regarding the degree or level of arguments, as his affidavit and testimony differed, making his testimony highly suspect and not credible. He found Vicky's statements were entirely hearsay and not admissible. He found Cynthia Schmidt, who was the dispatcher at Giddings, not credible. He found her opinion of Fennell was not relevant. Her testimony regarding his alleged statements at the funeral were contradicted by Thelma, Deborah Oliver, and Fennell. She's the one who says Fennell said at least a bitch got to wear her dress. He found the testimony Schmidt gave about Gary Joe Bryant. Apparently, I think she testified that there was some kind of encounter between Fennell and Gary Joe Bryant in which Fennell was aggressive. He found that to not be credible, and it was based on hearsay and was inherently unreliable, and that it conflicted with credible testimony from Nathan Lapham, which was that Bryant was not conducting an investigation and it would have been improper for him to do so, and that Schmidt waited an unreasonable amount of time to come forward, especially considering that she worked in law enforcement. I think maybe she testified that Gary Joe Bryant told her he was conducting an investigation and that Fennell threatened him or something along those lines. Admittedly, I'm not entirely familiar with the testimony she gave. But again, the gist of it is Judge Langley did not believe her testimony. Alicia Slater, I wish that the state had been able to play her interview on Dr. Phil, because that little smile, smirk, tilt of her head, she was sleeping with a black guy named Rodney, is just so blatantly false that I wish they'd been able to play that at the hearing. But they didn't need to, because Judge Langley did not find her to be a credible witness either. She is one of the people, though, who testified that Stacey was worried about Fennell finding out about the alleged affair. So she did do a good thing, because she ended up refuting testimony from these other witnesses who testified about the openness of said affair. But he didn't find that her testimony was credible because if Stacey was worried about Fennell finding out, why on earth would she tell a teenager she barely knew about said affair?
Yeah, that's always the funny things is, she's not going to tell her mom or her closest friends, but she's going to tell just random people.
And I still stand behind the statement that they're talking about an engagement ring that Stacey did not wear to work. And Slater has never said they were having lunch in the break room, but Slater's schedule and Stacey's schedule did not coincide. Because Slater was a cart girl and a bagger who would work regular open hours. Right. Stacey was a produce supervisor who came in to get the store ready to open, work during the early stages of the opening of the store, and then was off work. At the time Slater would be eating lunch, Stacey would probably be on her way home.
Exactly.
Giddings. So he also found that Slater gave 2 statements to investigators at the time of Stacey's murder, but didn't share this admission by Stacey with police or her friends or family. He found that she came forward in 2015 after reading media coverage surrounding the case, and that, again, her testimony was internally inconsistent. She was so adamant not to be involved in 1996 that she lied to police, but she willingly appeared on TV in 2019. He found she received a monetary benefit from the Dr. Phil show, and he found that she believes details about the case to be true, even though they're unsupported by anything in the record, including her statement that there was black skin found under Stacey's fingernails, which, aside from DNA, I don't know how that would be. Because skin under the fingernails is not going to be visually identifiable as Caucasian, African American, Latino, Asian, whatever. He also found that she was not credible because she had no memory of certain events at HEB at the time of Stacey's murder, including the reward, people wearing pink ribbons, increased law enforcement presence, testified to by Haas, and corroborated by other Reed witnesses. He went on to find Calvin Horton not credible because, again, he didn't come forward in 1996 or tell anyone until 2015 after watching media coverage about Reed's case. His testimony about statements made by his father, his mother, and Carol were rank hearsay and inherently unreliable, and that his testimony was contradicted by Carol's trial and 2017 testimony, and the court found her to be a more credible witness. And then Dickinson is another HEB employee who was found to be who gave testimony inherently inconsistent and inconsistent with her affidavit, which was written by Reed's counsel. He also found that her testimony about people at HEB keeping quiet about the case, such that she did not know Reed was arrested, is inconsistent with testimony given by other Reed witnesses. Finally, he found that Drs. Dana and Farley, their testimony was more credible than that given by Drs. Baker and Greg Davis, and that's for the reasons that will be discussed in Ground 4. He analyzed the procedural default, which means that these allegations could have been presented in Reed's first writ or at trial, and he found that the facts presented were known to Reed during his trial and before the filing of his prior applications, and that at trial he pointed the finger at Reed as an alternate suspect. So basically, there was procedural default. Latches, he made the same factual findings as in Ground 1. And basically, like, procedural default means that he should have presented this sooner.
Right. Well, that goes to the point we said at the beginning of the episode. None of this is there's nothing that has happened in the past 20 years that makes any of this evidence or testimony or witnesses available.
Mm-hmm.
The consistent theme is they came forward after,
Correct.
publicity around the trial. And then similarly, it's amazing just the internal inconsistency, even among Reed's own witnesses. And again, you see this in a lot of these cases. You can look at one particular witness statement and go, gosh, I really think that he's innocent because of this statement. But when you put all of them together, you realize how inconsistent they are and how the entire story doesn't hold up.
Correct. And I think that's where Reed consistently fails. When you look at each of these witnesses in isolation and you look at what they say in isolation, yeah, sure, it presents a very convincing impression of innocence.
Yes.
But the problem is that presumes that they are all absolutely telling the truth. And that is not the case. If they were telling the truth, they would have told it in 1996 when Stacey was murdered.
Right. And if they were telling the truth, they'd all be saying the same thing. Either Stacey was having a double secret affair where she told nobody, or it was out in the open and she was bringing him to HEB and flirting with him out in public.
Correct.
Which apparently Fennell would regularly drop in also and get in arguments with Stacey. So she's going to bring her boyfriend to where she works, where her cop husband might regularly drop in. So it just, it just doesn't make any sense.
Yet another factor or fact presented by Reed that doesn't line up with other facts that calls them into question, or, basically makes the whole argument turn into an illogical and unreasonable and inconsistent argument. So ground four.
And it goes to, I think, just throwing everything against the wall. Let's find a witness to say everything.
See what sticks. Correct.
Exactly.
Ground four was actual innocence. Reed did try to raise ineffective assistance, but that was not remanded because it could have been raised earlier. It was no doubt procedurally defaulted, and I don't think anything he could present is ever going to resurrect it. The factual conclusions he drew on the actual innocence claim was, first, that the CCA has repeatedly considered prior allegations of innocence, including drawing credibility determinations that are accepted by the trial court. Reed has presented inconsistent theories. He's offered multiple alternative suspects, including Fennell, Lawhon, and an unknown dark-skinned man. These inconsistencies diminish the credibility of his latest actual innocence theory. And that's the thing, too, that Reed's attorneys present this in a vacuum. They're like, pretend all these other writs never happened. What we said we didn't say it. And now this is our play.
Well, it's exactly like the West Memphis 3 case, where ignore that we told you yesterday it was stepfather number 1. Now it's stepfather number 2.
Correct. Because of a hair that's mitochondrially doesn't exclude that stepfather, right, which is no different than the fiber evidence that we have argued for years is not sufficient to link us to the murders.
Exactly.
Because a failure to exclude is still a failure to exclude, and it's not to the exclusion of all others.
Exactly.
But I think we're going to have to talk about that DNA testing debacle. That is what led to my breakup with Michael Carnahan. And I really, really want to get all those things out there, which I Did a little bit with Roberta, but I really want to unleash.
Right. There's a lot there.
Since you and I see eye to eye on the case, I think we would be able to get through it quite successfully.
Yeah, absolutely.
So, the judge also found that Reed has presented multiple alternative co-conspirators who are alleged to have assisted Fennell, among them Curtis Davis and David Hall and other unidentified individuals. The inconsistent and scattershot approach of co-conspirators also diminishes the credibility of the latest actual innocence theory, which again, Reed does not provide a cohesive answer to the question, how did Fennell get from Bastrop back to Giddings?
I think he was on that unicorn.
But why didn't somebody point out the rainbow trail from the unicorn dots?
Exactly.
So why didn't William Sappington? And one of the interesting things, and I think we'll get into it with across the closing arguments. One of the interesting things, William Sappington claimed to have heard arguments and fights and abuse, but he didn't hear a murder.
Exactly. Yes, exactly. That's where they always go a bridge too far, and it never holds up consistently. Yes, I can hear you yelling, but I can't hear you murdering.
Correct. Because it was silent. Sense. It was silent. Whatever Fennell did was silent.
Exactly.
So the next finding, and we're on 112, by the way, for those keeping a scorecard, inconsistent treatment. Reed has failed to accuse Hall and Davis when they testified at the 2017 hearing. The court found that this inconsistent and opportunistic treatment of supposed co-conspirators diminishes the credibility of Reed's actual innocence theory. The current time of death is inconsistent with the theory presented by Reed in his third writ, which claimed that Stacey was alive between 4:45 a.m. and 5:30 a.m. on April 23rd, 1996, based on the testimony of Martha Barnett. Now, based on various experts, Reed claims Stacey died hours before 3 a.m. That was Dr. Baker's testimony. Between 6 p.m. to 10 p.m. on April 22nd. That's based on an affidavit provided by Dr. Spitz. Before midnight on April 22nd. That's based on affidavit and testimony of Dr. Bodden. And 9:15 p.m. on April 22nd to 1:15 a.m. on April 23rd. That's based on like a fourth affidavit provided by Dr. Riddick. The inconsistencies between Reed's time of death theories, together with inconsistencies among his experts and shifting theories of time of death, diminish the credibility of his latest actual innocence theory. The current theory about Stacey's time of death is inconsistent with the prior claim that time of death could not be determined because of a lack of detail, which was a claim made by Dr. Riddick in an initial affidavit on behalf of Reed in an earlier post-conviction writ. And again, you can't criticize the state's time of death theory presented at trial if you can't find a single expert that presents a plausible time of death, and you have to keep going to multiple experts. I think they're looking, in Reed's case, they're looking at quantity over quality.
Yes.
So basically, if all these experts can produce all these different times, that doesn't undermine the state's original theory.
Yeah, all it tells you is, exactly. If your experts all are not agreeing, if they all disagree with one another, it makes the state's timeline as plausible as any of theirs.
Yes. And the judge went on to make specific findings regarding Reed's credibility, because his credibility is at issue in this case. The court found that he executed an affidavit in 2014, which was attached to his seventh writ. I believe it was also eventually attached to the request for DNA testing as well. in which he claimed he had a clandestine affair with Stacey and had sex with her late on the night of April 21st, 1996, or in the early morning hours of April 22nd, 1996, i.e., a day before her murder. His affidavit lacks credibility given that it was produced 18 years after events. His affidavit was inconsistent with his 1997 sworn statement in which he said, and I quote, "I don't know Stacey Stites, never seen her other than what was on the news. The only thing that I do know is what was said on the news is that she was murdered." End quote.
Well, again,
yeah, go ahead.
Oh, go ahead. I'm sorry.
No. You had a good point.
Well, I was going to say it goes back to the internal inconsistency because, again, if you're going to buy that Stacey is scared to death of fentanyl and that she is hiding this affair, what possible excuse would she have to be out at midnight or 1 a.m.? It doesn't make sense. If she's terrified of her fiance, what possible, oh, sorry, honey, I'm going to go out at 1 a.m. Like, it just doesn't make sense that if she is terrified of fentanyl, that she's going to be out sneaking around at 1 a.m. in the morning. It just doesn't make any sense.
Correct. Exactly. And, and this also is, they claim you can't believe anything Fennell said. And they also claim wrongly that the entire timeline is based on only Fennell's testimony. And that's not true. A majority of it is by necessity based on Fennell's timeline, based on Fennell's statements or testimony, because when two people live together, only those two people are going to know certain things.
Exactly.
However, a lot of the statements he made about her habits, her routine, were corroborated by her mother. They were corroborated by Andrew Cardenas. They were corroborated by Ron Haas. Her schedule was corroborated by HEB. That's not solely coming from Fennell.
Right.
Her schedule was corroborated by Carol. And Carol testified that she woke up after falling asleep watching TV around 1 o'clock. She went to bed and that she heard a door open and footsteps on the stairs sometime after she went to bed, but she doesn't know an exact time. That's consistent with Stacey leaving for work. So she can't testify that she definitely knows Stacey left for work that morning, but circumstantially, you could draw that inference from her testimony.
Right. It's very consistent.
And I would expect if Fennell really killed her, he would have said, I woke up, we had a discussion, she got her water, I saw her walk out the door, I looked at the clock, it was exactly 3:05 a.m.
Right.
Because when you're trying to create when you commit a crime, you try to create an alibi for yourself. Exactly. You do not say things that give you zero alibi.
Exactly.
And so, I mean, I would expect if he was creating an alibi, he would have been sitting by the pool smoking a cigarette, and she came and told him goodbye and left. And he was talking to a neighbor.
Right.
I mean, I'm speculating, but trying to show people why what they say doesn't make sense actually makes perfect sense. Because that's a big argument on Jordan Smith. Well, everything's from Fennell. Well, it's not. It's corroborated by a lot of people. Well, he doesn't have an alibi. Well, because he was asleep. And when people live together and something happens to one, the second one isn't going to have a good alibi because the only person that could have given him an alibi is now dead.
Exactly.
The court also found that in 1996 or 1997, Reed told transport officers, including Maldonado, that he last saw Stacey a few days before her murder, which is longer than the 21st or 22nd. The court found that his specificity in 2014 about when and where he had sex with Stacey is inconsistent with a 2001 interview where he said he and Stacey had sex a day to a day and a half before her murder. So he's giving different time frames that then are brought into the persistence of sperm arguments. His affidavit references a supposed encounter with Fennell, claiming his cousin Chris Aldridge as a witness. Aldridge's account of this encounter has, Aldridge's account of this encounter was found to be unbelievable when relayed in Reed's first writ. Reed's recitation of an event found to be unbelievable diminishes his credibility. If it didn't happen, and now you're saying it did, you ain't believable. Reed previously denied knowing Connie Y in response to an allegation of sexual assault until he was confronted with biological evidence. Then he claimed a secret relationship with her. His testimony via affidavit is not credible, and he is not credible. So those are specific findings, numbers 122 and 123, made by Judge Langley. As to the credibility of other witnesses, as to just the actual innocence claims, the judge incorporates his credibility determinations made in grounds 1 and 2, which include the alleged statements made by Fennell. And it looks like Kyle dropped off, but he's back. Yay. All right. So we're on supposed recantations of testimony by Dr. Bayardo first. The court basically found that the 2012 declaration that Reed purports to have recanted testimony by Dr. Bayardo regarding time of death, persistence of intact sperm, and observance of injuries to Stacey's body, specifically her anus, are not a recantation as they are portrayed by Reed. And remember, Bayardo's testimony at trial regarding time of death was a time of death between 3 and 5 a.m., give or take an hour or two. And Bayardo specifically testified that this was an estimate. That's all time of death ever is. And Reed's experts purport, in some cases, like Dr. Bodden, to be a time of death given with pinpoint accuracy. But they're not. Anybody can give an estimate. And right. Bodden has even, I'm skipping a little bit ahead, spoiler alert, Bodden has testified that experts, pathologists, forensic pathologists, can look at the same set of factors, set of evidence, and come to different opinions.
Yeah, you see that in trials all the time where you have competing experts looking at the exact same data points and have two different estimates, and it usually does skew on what they're trying to conclude from that data.
Correct. And I think the other thing too is that Reed is trying to say that Bayardo lied at trial, or that the prosecution lied at trial when they gave this estimate. Of course, they also portray Bayardo's estimate as being 100% based on Fennell's statements. That's not true. I think part of the estimate is based on what Stacey was wearing when she was found. And while this is extrinsic evidence, it is important evidence. And forensic pathologists do need to sometimes take extrinsic evidence about the crime scene or the crime or the location and position and appearance of the body into factor in when coming to an estimate of time of death. You know, you don't want to give a time of death when you have multiple witnesses who were with the victim and know the victim was alive and well.
Yeah, exactly.
You know, also Karen Blakely, the allegation that her testimony has been recanted by the Texas DPS is not supported by the statements made in the letter from the DPS relied on by Reed, which is that the DPS did not believe that Ms. Blakely's testimony constituted negligence or professional misconduct, and the DPS had no duty to correct her statements. So again, the judge had found that Reed's claims regarding allegation regarding recantation by DPS of Blakely's testimony is untrue, not credible. Again, Blakely's testimony regarding the persistence of sperm was thoroughly challenged at trial. The jury was given information about the article relied on by Reed's experts at this hearing, spoiler alert, and also Dr. Elizabeth Johnson, who testified on behalf of Reed, gave a different estimate of persistence than that given by Blakely. So the jury had Blakely's estimate and Johnson's estimate, and they obviously made a call as to which one was more credible. But Blakely's was not the sole estimate. Megan Clement, again, the letter from Bode finds the some statements unsatisfactory, but doesn't give a specific explanation as to what statements were specifically unsatisfactory. Again, the letter by Bode does not recant Clement's trial testimony that she has observed intact sperm in sexual assault kits that she has processed, or has not observed intact sperm after longer than 24 hours in her experience. And that was her experience. That's not improper for her to have testified about her experience. And Reed has never presented anyone who has said that that was improper. Welcome back, Kyle. So the court went on to find that none of the testimony of Dr. Bayardo, Blakely, or Clement has been recanted by the witnesses or the employers. So that claim fails. Then he moved on to the supposed confessions made by Jimmy Finley. And basically, Arthur Snow's credibility was resoundingly found to be lacking for multiple reasons, including inconsistencies between his trial testimony and his affidavit, in which in trial he said he was a member of the AB for 20 years, between 87 and 2007, but in his affidavit he claimed to have been in the AB when he talked to Fennell in 2010. He claimed he left the Connolly unit because of an accusation of extortion made by Fennell, but a person from Department of Public Safety or Texas Department of Criminal Justice testified that he left the Connolly unit on a bench warrant. There was someone else who also testified that he obtained another transfer by lying about being a practicing Native American or a person practicing Native American religions. And so he wanted to be transferred to a prison where he could smoke cigarettes. So he was again not found to be credible, and the judge did not believe that Jimmy Fennell ever confessed to Arthur Snow for various reasons. And in paragraph 155, it's very enlightening. Arthur Snow's criminal record is cited, and this is based on Arthur Snow's admission of convictions on the stand.
Yeah, and all of these are, I forget the proper word, but all crimes of dishonesty, and faking things, which doesn't exactly set the stage for somebody who's honest.
Well, he has 14 of them are crimes of dishonesty. And those are 10 forgeries, 2 thefts by check, and 2 credit card abuse. Credit card abuse means he obtained somebody else's credit card and used it and presented himself as the person. And that usually happens with an older person.
Yeah.
It could also be where he took a credit card out in a child's name with a child's stolen information. But yeah, these are all crimes. They're called crimes of moral turpitude.
Right.
And also another thing that counted against his credibility was his attempt to invoke the Fifth Amendment during his cross-examination by the state. So, and I really believe that Arthur Snow pulled one over on Reed's investigators and attorneys. And I think that because he's a con artist, he gave them a very good story and they ate it up with a spoon.
Well, yeah, I mean, what better way just to pile on the whole sort of racial straw man by invoking the Aryan Brotherhood?
And not only that, but I mean, he gave them a confession to murder of Stacey from Jimmy Finley. The thing that in 23 years of post-conviction litigation, they never had. And it was this confession that really probably spurred the CCA to remand these claims. There were, inculpatory or statements that could be taken as inculpatory. She got what she deserved. The bitch got to wear the dress. And then this confession that, ultimately is what the CCA decided.
Right.
Tip the balances. And so this is where, again, we see They don't have to present the merits. They just have to present a colorable claim.
Yes.
That is worthy of further development. And this claim of a confession by Jimmy Finley is a colorable claim of actual innocence that passes muster to get further development. And Bordelon, likewise, not found to be credible. The court did not believe that Jimmy Finley confessed to either Snow or Bordelon. So I'm going to kind of go through these a little bit more quickly now.
Yeah, well, this is
actual innocence.
Yeah, well, and this is an area too where, again, on the other side, when you have sort of the jailhouse snitch that that points to the convicted and the convicted confessed, well, then there's 1,000 reasons why jailhouse snitches are not to be believed. But if they go to the other way, then suddenly they're the most credible, honest people in the world.
Correct. Because they're not getting any benefit. They don't have a dog in the fight. They're just coming forward out of the goodness of their own hearts. And they have to be telling the truth. And to try to argue that a person convicted of that many crimes of moral turpitude like Arthur Snow has got to be telling the truth is laughable. Bordelon is a little bit better. Bordelon's credibility was hurt more by his inconsistencies between his testimony and his affidavit, and the fact that he had to have his memory refreshed on the stand by his affidavit when he initially began testifying. And his affidavit was only signed a year and a half before. In the forensic science, and this is the feather in the Innocence Project's cap, where they base most of their arguments on forensic science. Forensic science cannot be wrong. But in this case, their reliance on forensic science has been basically negatively impacted by the fact that they keep bringing different forensic scientists forth, and the different forensic scientists can't agree on the same estimate of time of death. So where Dr. Bodden says it was before midnight, Dr. Spitz says it was between 6 p.m. and 10 p.m. Riddick says it was between 9:15 on the 22nd and 1:15 on the 23rd. which is really, 1:15 on the 23rd comes within the window, Dr. Bayardo. And I think the other false impression that the Innocence Project keeps giving is that because these experts say otherwise, Dr. Bayardo's time of death is a lie, or his estimate is a lie. And that's another place where they are shooting themselves in the foot, because they're calling Dr. Bayardo's estimate a lie when they can't provide a single expert that has a single credible estimate. Spitz's time of death estimate includes a long period of time where Stacey was alive and well with her mother.
Right. Yeah, that was always my favorite.
Riddick's time of death estimate, but he said before that an accurate time of death can't be determined because they don't have enough evidence. And where Baker and Davis hurt themselves is they relied only on rigor and lividity from pictures and the crime scene video, and they refused to consider, or at least Dr. Baker refused to consider, how Stacey's body was dressed when it was found. Similar to Dr. Bodden saying, well, we don't know how the zipper got broken. Maybe it was broken when she put on the pants. If the zipper broke when she was putting on the pants, she would have put on different pants.
Exactly.
She would not have gone out of the house with a broken zipper.
Exactly.
I have had that exact scenario happen. I have busted a button while trying to button a shirt. And so guess what? I didn't wear that shirt.
Exactly.
Or I've had the button, not busted the button, but the button came off because it was held together with a single thread.
Right.
So,
and these guys too. I mean, I'm not saying they're dishonest, but these guys, they're basically paid experts of the Innocence Project to go in and testify and give you return a reasonably ethical answer to a timeline that makes the convicted look innocent. I mean, this is what these guys do.
This is another interesting thing. Apparently, Dr. Baker and Dr. Greg Davis were not paid. They did all of this all on their own, including Dr. Baker bringing himself to Texas on his own dime. Now, I would like to see the state inquire into this, because I really do not believe that this is what happened, but this was a common theme in Andrew McCrae's closing argument. But the thing, like I said, that hurt Baker was he wouldn't consider how Stacey was dressed. He only wanted to consider this rigor and lividity. What hurt Dr. Greg Davis is that he signed a, quote, peer review report, which was not authored by him, but was authored by counsel for Reed, and contained only argument of Reed's counsel, or nothing more than argument of Reed's counsel. And that led to basically the court finding that Drs. Dana and Dr. Farley were more credible than Drs. Baker and Dr. Greg Davis.
Wow.
And there are several paragraphs. In fact, the remainder of to paragraph 184 is basically discussing the forensic evidence, including the fact that Reed has been linked to Stacey's murder with irrefutable DNA evidence found inside and on and around her body. That's paragraph 184. And then very quickly, we'll talk about paragraphs 185 through 189, which discuss the credibility of the extraneous offenses alleged during the punishment phase of Reed's trial, in which the court found that Connie, Lucy, A.W., Caroline, Vivian, all credibly testified that Reed sexually assaulted them. Linda testified that he attempted to sexually assault her, but she was able to escape. And the court found that at trial, Reed did not open the door to this testimony during the guilt phase. But that if he had presented this theory of defense at trial that he presented at this hearing, these women would have been able to testify in rebuttal after the defense case closed. And that is a very important finding. Basically, the court said Reed mounted a full-throated challenge to identity and consent during the evidentiary hearing that he did not do at trial. And again, the court found in paragraph 189, which is the final factual finding, that the punishment phase testimony of Connie, Lucy, A.W., Caroline, Vivian, and Linda is credible, and their testimony was corroborated by credible testimony. And this is even without considering the bill of exception testimony offered by the state from Vivian, Linda, and Miller. This is important because yet again we have the punishment phase testimony being declared by a court to be sufficient to believe the extraneous offenses alleged against Reed are reliable.
Right. When you think about motive, they have nothing to gain out of testifying at his guilt phase. All they're doing is subjecting themselves to sort of, the pain of getting on the stand and talking about a horrible experience publicly.
Correct. And Reed's, aside from David Fisher's bullshit about Connie and Lucy and A.W. and Caroline and Vivian and Linda, Reed has never presented anything that undermines the credibility of the punishment phase testimony from the first volume of the punishment phase to the last volume of the punishment phase. Their only tactic is close your eyes, put your fingers in your ears, and pretend it doesn't exist. Because he was never tried and convicted of these offenses. We're getting close to 6 o'clock, so I am going to go through very quickly the legal conclusions. I don't think they really require a lot of explanation. I will post these case notes after I fix a couple of little typos. I will post these case notes with the YouTube video. I'll post a link to the Rodney Reed is guilty site, and people can look at the full summary of everything on the court's factual findings for themselves. So on the suppression of evidence ground 1, first of all, the judge found that laches applied, that this ground was barred by laches for the reasons in the factual findings. He did do a merits review. He cited the legal standard for Brady, which is suppression of favorable evidence that is material, meaning a reasonable probability of a different result had the suppressed evidence been disclosed and presented at trial. The evidence central to a Brady claim must be admissible in court. So hearsay is not admissible. Uncorroborated testimony is not admissible, or is not material, rather. And his legal conclusion is that Reed basically failed to prove by a preponderance of the evidence that there were any Brady violations based on the statements from Derleth, Fletcher, and Clampett, because none of them were part of the investigative team. None of them told investigators about their information. They all waited years to come forward, and their testimony was inherently unreliable and not credible. On ground 2, the unknowing use of false testimony, basically the court found that legally this ground was basically not the non-retroactivity by Teague versus Lane, which is a Supreme Court decision, applied to this ground. And so from a legal standpoint, this claim is barred because Reed's conviction became final in 2001. The first time this particular claim was recognized was in 2009. It was a new rule in 2009, but because Reed didn't raise it, and he would have had to raise it in 2009 when it first became available, he waited too late to raise it. He went on to do a merits analysis, and again, legally finding that he can't raise the claim because it's barred by procedural default latches, whatever, he could stop there. But he goes on to analyze on the merits. Again, he found that latches barred ground 2, and continued with merits review, found procedural default, and ultimately found that he did not prove by a preponderance of the evidence that Fennell lied or misleadingly testified at trial, and found procedural default as to the claims regarding Blakely and Bayardo and Clement. Again, this will all be posted. And finally, ground 4, actual innocence legal standard, is a Herrera type claim. Legally, he found that Reed had not proven by clear and convincing evidence that no reasonable jury would have convicted him of capital murder, and he had not proven actual innocence with clear and convincing evidence, and recommended that the Court of Criminal Appeals deny relief on grounds 1, 2, and 4. So that is basically the findings of fact and conclusions of law. While we'll discuss this at a later date, Reed is presenting this as a rubber stamping of the state's proposed findings. Again, I found some distinctions and differences between the proposed findings submitted by the state and those ultimately signed by Judge Langley. So I disagree with their interpretation. There are differences in the number of paragraphs. There are differences in the structure of the proposed findings and the ultimately entered findings. So, I find that to be I haven't done a paragraph by paragraph comparison, although I may end up doing that at some point in time, depending upon what the state does, because hopefully the state will do that for me in their response to Reed's objections and amended objections, which have been filed with the Court of Criminal Appeals. It looks like I don't think we're actually going to get to the closing argument, because we're at 6 o'clock now, and I don't want to risk Zoom cutting us off.
Right. And when it's worth, yeah, exactly.
But, basically the argument during closing, I'll post my notes regarding the closing argument, but I think the takeaway, first of all, is that a lot where the closing says that everything's based on Fennell, a lot of the information is actually corroborated by Carol. Some of it may have even come from Carol because, for example, when Stacey got home from work is something that Carol knew, not Fennell, because Fennell was still at work when Stacey got home. I think Reed wants to pick and choose and cherry pick from Curtis Davis' CNN interview, because Reed never once mentions, his attorneys don't mention, that in that CNN interview, Curtis Davis said, I don't think Jimmy Fennell could have killed her. If Jimmy Fennell had contacted me and said, I accidentally killed her, you got to help me, Curtis Davis said I would have arrested him.
Right.
And we've had Tim Sparkman corroborate that based on his friendship with Curtis Davis.
And I think people under club what a big risk that is for somebody that, oh yeah, people would just easily risk their life to cover up a crime for somebody that, yeah, they may be lifelong friends, but it's not like it's your child.
He wouldn't have resisted his freedom.
Exactly.
And I think another statement that Curtis Davis made in that interview that is telling is that Rodney Reed is the person who strangled and murdered Stacey Stites. That Rodney Reed raped and murdered Stacey Stites. Curtis Davis said that in the interview. How they can ignore that and try to say, he said, you know, he didn't even say Jimmy lied on the stand. He says his recollection is Jimmy said, I didn't take her to work because I was out drinking. But he never said we were out drinking. He didn't have any firsthand information about who Jimmy was with, how long he was out, what time he came home, what time he, you know, where he was, or any of that. He had no firsthand information. His recollection of Jimmy's statement was he was out drinking. And then Curtis Davis kind of filled in the blanks by assuming that Jimmy was out until 10 or 11 o'clock, that Stacey was asleep by the time he got home, that he decided not to come home because he didn't want to wake her up, et cetera, et cetera, et cetera. But a lot of that was assumptions being made by Curtis Davis and not firsthand knowledge based on information either that contradicted Fennell or that was provided to him by Fennell. And I do want to highlight there are some stupidest, dumbest statements made by attorneys. And I'm trying to find the first one. But one of the ones that stood out for me was basically Andrew McCrae was criticizing the investigators for not finding Susan Hugan, Brenda Dickinson, and these other HEB witnesses who provided the testimony at the hearing 20 years later, who provided affidavits to read 20 years later. One of the first dumbest statements I have to jump back is that this was made by Jane Pucher during her part of the closing. The fact that Miss Stites was wearing her work uniform or part of her work uniform when her body was found is only relevant if you believe Fennell's account that Stacey left the house alive that morning. Otherwise, it means nothing.
Oh, that's crazy.
And Jane Pucher is on video after the hearing saying that they are playing to the court of public opinion.
Right. Yeah, that seems to be exactly what this is about.
So,
can you get enough biased coverage to, you know, sway some more people that an innocent man is going to be killed?
And here's the second dumbest statement. This one was made by Andrew McCrae. How does an HEB employee know what is important to a law enforcement officer or an attorney or a jury or a judge? How do they know that? They don't know what's important. They have no training. They were all willing to answer questions, all of them. So the police didn't find them. The police didn't psychically glean that they had useful, relevant information. And that's what the police were supposed to have done based on this statement. Now, I present that in a situation in which one's coworker is engaged to a physically abusive man, where one has witnessed signs of physical abuse on that woman's wrists, where one has witnessed belligerent, aggressive encounters between fiance and woman in the store that have led the girl to go in the back and cry, and one has met the girl's clandestine lover, and she's engaged to this violent, abusive cop, and she turns up murdered, I would say, get thee to the police. What you know is important, and anybody who doesn't know that is stupid.
Right, and not to mention that apparently these HEB folks just chit-chat and tell each other their deepest, darkest secrets that they don't tell anyone else. I would assume they would have all gotten together in the lunchroom, as
Yeah.
apparently they always did, and say, gosh, aren't we all concerned about all this stuff that we all know? We should all go together.
And there's a third dumbest statement again, Andrew McCrae. Witnesses are not expected to come forward. They are there to answer questions. They shouldn't have to do the state's job. Again,
Yeah, that's insane.
police are not psychics. They do not know what people out in the world know about a given crime.
He's probably never, there's this little thing, I think, is it called Crime Stoppers, maybe?
Yeah.
Where
And there are things that say, see something, say something.
Right. Or wanted
That is
posters
not
from
aimed
back
at
in the Old
police.
West. Yeah, haven't we all seen the wanted poster where they say, hey, we want information about this crime. Have you seen this person?
And,
That's
another
hilarious.
another dumb statement, and this is going to end up being dumb things said by IP attorneys. Schmidt, that the police were somehow deficient for not gleaning that Schmidt knew things that were important when she said no with her mouth, but shook her head yes. In interviews. This is a woman who says, I tried to give them cues and they didn't catch them. And that, I didn't say close the door, but I tried with my eyes to I looked at the door and closed my eyes, and that meant close the door. I gave them these nonverbal cues because they were interviewing me with an open door. And I couldn't talk with an open door.
Right. So now all of a sudden they're super sophisticated.
Yeah.
Whereas in the previous argument, they're not sophisticated at all.
Right. So yeah, that they were supposed to be super sophisticated and glean these nonverbal cues being given by Schmidt.
Right, exactly.
Who had important things to say, but was prevented from saying them because the cops were interviewing her with an open door. I would have said, close the fucking door, you moron.
Exactly.
Exactly. I would have been like, I know things, but I need the door closed before I can tell them to you.
Yeah, you're not smart enough to ask them to shut the door. But
I'm not talking to you here.
Yep.
Give me your card. I'll call you, and then I'll call him and I'll talk to him outside the police station. And he claims that she tried to call a ranger and the ranger never called her back. So then she just presumed whatever she had to say wasn't important.
Exactly. Yeah, it doesn't make any sense.
I would have gone down to the ranger station and said, you motherfucker, I called you. Why didn't you call me back? Exactly. I would have kept calling. I work for a law firm, and when I'm trying to call a client or an insured or a witness and I keep getting their voicemail, I call and leave voicemail. I've emailed them. I've texted them. I've called them on their cell phones. I had somebody I called after 5:00 because they were screening calls during the day, but after 5:00, they were just picking up, and I could tell by oh, hey, they didn't really want to talk to me, but I caught them.
Right.
So they had no choice.
None of these arguments are internally consistent. It just doesn't make sense. They make sense one off, but when you put two of them, when you juxtapose two of them, it doesn't make any sense.
And another dumb statement is many witnesses tangentially corroborate each other. But if the state's case was built on tangential corroboration by witnesses, the IP would be breaking it down brick by brick, 100%. Witness by witness. And that's pretty much, that was it. The IP got to start the argument, and then they got to rebut because they are the mover. They are the ones presenting the case. They are the ones presenting the evidence. And so they got to rebut the state's. And I think the state did a really great job of building a cohesive case and demonstrating that their case has not changed. Their theories have not changed. The evidence has not changed. And again, because I didn't really get to a more full analysis in this, and you and I didn't get to talk about it a little bit more, I will post this closing argument summary on the page as well, so that people can read the full closing arguments and decide for themselves as far as the credibility of the attorneys involved. And so I think that is pretty much it. For us. Oh, Kyle, where'd you go, Kyle? I think he got disconnected again. I was hoping he and I could discuss and wrap it up a little bit, but it looks like maybe not. So, I guess we will just close. I'll give Kyle another minute. And it looks like we're going to lose Kyle. We'll be back next week, and we will reserve a few minutes next week to kind of wrap this one up. So let me do my outro now. Thank you for listening to Based in Fact, a true crime podcast with Lisa O'Brien and guest co-host Kyle. If you like the show and want to know more, you can find us on Facebook or follow me on Twitter at O'BrienLN. Join us next week for State of Texas versus Darnell Hartsfield and Romeo Pinkerton. On September 24th, 1983, the bodies of David Maxwell, Joey Johnson, Monty Landers, Mary Tyler, and Opie Hughes were found in an oil field in Kilgore, Texas. The case remained unsolved until a tip and DNA evidence found at the restaurant led to Hartsfield and Pinkerton, who were each incarcerated in Texas prisons at the time of their identification. Kyle and I will talk about the murders and the challenges to solving the case, which included rumors and suspicion surrounding a politician's son. We'll also talk about the DNA results that suggest a still unidentified third perpetrator is out there. Until then, have a great 2 weeks and stay safe, or a great week and stay safe. Good night.